source of Blackstone's ideas for law. So while 34% of the founders' quotes came directly out of the Bible, many of their quotes were taken from men, like Blackstone, who had used the Bible to arrive at their own conclusions. Numerous components of our current government can be shown through these early writings to have their source in biblical concepts. For example, the concept for the three branches of government can be found in Isaiah 33:22. The logic for the separation of powers was based on Jeremiah 17:9. The basis of tax exemptions for churches was found in Ezra 7:24, and many other examples. This biblical heritage was so well understood during the early years of the nation, and the writings of the numerous founding fathers were so well known, that in later years the Supreme Court ruled in the founders' intention, keeping biblical principles as the basis. For example, notice this ruling by the U.S. Supreme Court in 1892. The court said, "No purpose of action against religion can be imputed to any legislation, state or national, because this is a religious people. This is a Christian nation." What would lead the court to conclude that we are a Christian nation? This case was not long, only 16 pages in the court records, but the court provided 87 different historical precedents to support its conclusions. The court quoted the founding fathers, the acts of the founding fathers, the acts of the Congresses, the acts of the state governments, and so on. At the end of 87 precedents, the court explained that it could continue to cite many additional precedents, but that certainly 87 were sufficient to conclude that we were a Christian nation. Keep in mind that the court provided 87 precedents in this case. This is important because the courts based their decision on precedents. To the court, it is important to go back and examine both history and rulings from previous cases so that the court can continue to be consistent in its present rulings. We'll return to the importance of precedents a little later. In 1844, a school in Philadelphia announced that it would teach its students morality, but not religion. It believed that it didn't need Christianity in the Bible, that it could teach morality without them. Sounds just like schools today. This policy, among others, caused this case to come before the U.S. Supreme Court. Some of the justices on the court at this time had been appointed by James Madison. Notice what the Supreme Court told that school. "Why may not the Bible, and especially the New Testament, be read and taught as a divine revelation in the schools, its general precepts expounded and its glorious principles of morality inculcated? Where can the purest principles of morality be learned so clearly or so perfectly as from the New Testament?" The Supreme Court of the United States ruled that schools would teach Christianity in the Bible, the source of morality. Today we hear just the opposite. Few realize that today's rulings by the court often repudiate rulings delivered by the founding fathers themselves. In 1811, a court made a ruling which was subsequently cited by the U.S. Supreme Court. That court declared, "Whatever strikes at the root of Christianity tends manifestly to the dissolution of civil government." Although this case dealt with a man who went into a profanity fit, profanity wasn't the problem. It was the intent of his profanity. For it had not been a moment of anger or a temporary loss of control, but it was a deliberate and a planned act. He had even taken the time to write it out and distribute it. In that writing, he had maliciously and capriciously attacked Jesus Christ, declaring that Jesus Christ is so-and-so, or God is so-and-so, or the Bible is such and such, continuing through a string of accusations and profanities against Jesus Christ and the Word of God. The court explained that the problem with his writings was that an attack on Jesus Christ was an attack on Christianity. An attack on Christianity was an attack on the foundation of the country. Therefore, an attack on Jesus Christ was equivalent to an attack on the country. This man was sentenced to 3 months in prison and a $500 fine for attacking the country by attacking Jesus. And notice the date of that case, 1811, nearly 2 decades after the First Amendment was in place. The First Amendment never intended to separate Christian principles from government. Yet today we so often hear the First Amendment coupled with the phrase separation of church and state. The First Amendment simply states, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." Obviously, the words separation, church, or state are not found in the First Amendment. Furthermore, that phrase appears in no founding document. While most recognize the phrase separation from church and state, few know its source. But it is important to understand the origins of that phrase. What is the history of the First Amendment? The process of drafting the First Amendment made the intent of the founders abundantly clear, for before they approved the final wording, the First Amendment went through nearly a dozen different iterations and extensive discussions. Those discussions, recorded in the U.S. Congressional records from June the 7th through September the 25th of 1789, make clear their intent for the First Amendment. By it, the founders were saying, "We do not want in America what we had in Great Britain. We don't want one denomination running the nation. We will not allow all to be Catholics or Anglicans or any other single denomination. We do want God's principles, but we don't want one denomination running the nation. This intent was well understood, as evidenced by court rulings after the First Amendment. For example, a 1799 court declared, "By our form of government, the Christian religion is the established religion, and all sects and denominations of Christians are placed on the same equal footing." Again, note the emphasis. We do want Christian principles, we do want God's principles, but we don't want one denomination to run the nation. Thomas Jefferson, to whom the now popular phrase separation of church and state is attributed, also believed, as did the other founders, that the First Amendment simply prevented the federal establishment of a single denomination, a fact he made clear in a letter to Benjamin Rush. In that letter, Jefferson committed himself as president to not allowing the Episcopalians, the Congregationalists, or any other denomination to achieve what Jefferson called the establishment of a particular form of Christianity. So what is the source of Jefferson's now infamous phrase? On November the 7th, 1801, the Baptists of Danbury, Connecticut wrote Jefferson concerned that the guarantee of the free exercise of religion appeared in the First Amendment. To them, this suggested that the right to religious exercise was a government-granted rather than a God-granted right, thus implying that someday the government might try to regulate religious expression. They believed that freedom of religion was a God-granted, unalienable right, and that the government should be powerless to restrict religious activities unless, as the Baptists explained, those activities cause someone to, quote, work ill to his neighbor. Jefferson understood their concern. In his response on January the 1st, 1802, he assured them that the free exercise of religion was indeed an unalienable right and would not be meddled with by the government. Jefferson pointed out to them that there was a wall of separation between church and state to ensure that the government would never interfere with religious activities. Today, all that is heard of Jefferson's letter is the phrase, a wall of separation between church and state, without either the context or the explanation given in the letter or its application by earlier courts. The clear understanding of the First Amendment for a century and a half was that it prohibited the establishment of a single denomination. National policies and rulings in that century and a half always reflected that interpretation. For example, in 1853, a group petitioned Congress to separate Christian principles from government. They desired a so-called separation of church and state, with chaplains being turned out of Congress, out of the military, etc. Their petition was referred to the House and the Senate Judiciary Committees, which investigated for almost a year to see if it would be possible to separate Christian principles from government. Both the House and the Senate Judiciary Committees returned with the reports. The following are excerpts from the House report delivered on March 27, 1854. The Senate report was very similar. The House report said, had the people, the Founding Fathers, during the Revolution had any suspicion of any attempt to war against Christianity, that revolution would have been strangled in its cradle. At the time of the adoption of the Constitution and its amendments, the universal sentiment was that Christianity should be encouraged, but not any one sect, denomination. The report continued. It said, in this age, there is no substitute for Christianity. That was the religion of the founders of the Republic, and they expected it to remain the religion of their descendants. 2 months later, the Judiciary Committee made this strong declaration. It said, the great, vital, and conservative element in our system, the thing that holds our system together, is the belief of our people in the pure doctrines and the divine truths of the gospel of Jesus Christ. The committees explained that they would not separate these principles, for it was these principles and activities which had made us so successful. They had been our foundation, our basis. During the 1870s, 1880s, and 1890s, yet another group which challenged specific Christian principles in government arrived before the Supreme Court. Now, Jefferson's letter had remained unused for years, for as time had progressed after its use in 1802, and after no national denomination had been established, his letter had fallen into obscurity. But now, 75 years later, in the case Reynolds versus the United States, the plaintiffs resurrected Jefferson's letter, hoping to use it as an issue to their advantage. At that time, the court printed a lengthy segment of Jefferson's letter and then used that letter on separation of church and state to again prove that it was permissible to maintain Christian values, principles, and practices in official policy. For the next 15 years during that legal controversy, the Supreme Court utilized Jefferson's letter to ensure that Christian principles remained a part of government. Following this controversy, Jefferson's letter again fell into disuse. It remained silent for the next 70 years until 1947, when in the case Everson versus Board of Education, the court, for the first time, did not cite Jefferson's entire letter, but selected only 8 words from it. The court now announced, the First Amendment has erected a wall of separation between church and state. That wall must be kept high and impregnable. This was a new philosophy for the court. Why would the court take Jefferson's letter completely out of context and cite only 8 of its words? Dr. William James, the father of modern psychology and a strong opponent of religious principles in government and education, perhaps explained the court's new strategy when he stated, "There is nothing so absurd, but if you repeat it often enough, people will believe it." This statement precisely describes the tact utilized by the court in the years following its 1947 announcement. The court began regularly to speak of a separation of church and state, broadly explaining that this is what the founders wanted, separation of church and state. This is their great intent. The court failed to quote the founders. It just generically asserted that this is what the founders wanted. The courts continued on this track so steadily that in 1958, in a case called Bear versus Kohlmorgen, one of the judges was tired of hearing the phrase, and he wrote a dissent warning that if this court did not stop talking about separation of church and state, people were going to start thinking it was part of the Constitution. That warning was in 1958. Nevertheless, the court continued to talk about separation until June the 25th, 1962, when in the case Engel versus Vitale, the court delivered its first ever ruling which completely separated Christian principles from education. The court struck down school prayer. Even the World Book Encyclopedia 1963 yearbook noted that this case was the first time that there had been a separation of church and state in education. In the 1962 case, the court redefined the meaning and application of a single word, the word church. For 170 years prior to that case, the word church, as used in the phrase separation from church and state, was defined to mean a federally established denomination. However, in 1962, the court explained that the word church would now mean a religious activity in public. This was the turning point in the interpretation of the First Amendment. Understand what the court has just announced. No longer would the First Amendment simply prohibit the establishment of a federal denomination, it would now prohibit religious activities in public settings. This current doctrine of separation is a brand new doctrine. It is not something from the Founding Fathers, and it is not in any founding document. Even outside observers recognize that this policy is a recent one, yet notice how much has been relinquished in recent years under this new doctrine. School prayer was the first casualty of the redefinition of the First Amendment in the 1962 Engel case. School prayer had never before been challenged, for clearly school prayer had never established a national denomination and therefore had always been acceptable. But under the new definition, school prayer definitely was a religious activity in public and was therefore now deemed to be unconstitutional. That 1962 case, which first redefined the First Amendment and then removed school prayer, was notable in a number of aspects. Recall that the 1892 Supreme Court case offered 87 precedents to maintain the inclusion of Christian principles in our laws and our institutions. Well, this 1962 case, which removed school prayer, was just the opposite. It was the first case in court history to use 0 precedents. The court quoted 0 previous legal cases, and without any historical or legal base, the court simply made an announcement. We'll not have prayers in school anymore. That violates the Constitution. A brand new direction was taken in America. Within a 12-month period of time, in 2 more cases in 1963, the court had not only removed prayer, but also Bible reading, religious classes, and religious instruction. This was a radical reversal. A book from 1946 illustrates this. This book is titled Bible Study Course of the New Testament for Dallas High Schools. On the cover page, it explains that this book was authorized by the Board of Education on April 23, 1946, and it was printed in the Dallas Public Schools print shop. The introduction further explains that this was a credit course toward graduation in Dallas high schools. Now, this wasn't a bland course on the New Testament. Lesson 1 begins with the Gospel of John, chapter 1, and studies the pre-existence of Christ. Now, notice the questions based on John chapter 1. Where was Christ before he was born on earth? What titles does John apply to Christ in this chapter? For what purpose was John sent by God? Name 5 things the angel told Mary concerning her child Jesus. What does the word Jesus mean? How did the angel explain the miraculous births of John and Jesus? And continues right on through the lesson. At the end of lesson 1 is memory work. Memorize the pre-existence of Christ. In the beginning was the Word, and the Word was with God, and the Word was God. All things were made by Him, and without Him was not anything made that was made. This was a textbook for public schools in 1946. What had occurred in the 1962 and 63 rulings was a radical reversal of national policy prior to that point. It was in the Abingdon v. Schempp and Murray v. Curlett decisions on June the 17th, 1963, that the court not only reaffirmed its ban on school prayer from the previous year, but further reached out and banned school Bible reading. Recall that in the brief survey already presented, the founders relied on the Bible, early textbooks quoted the Bible and used it as part of the alphabet, and earlier Supreme Court cases ruled that a school must teach religion in the Bible. Therefore, on what